If you want to understand whether American power still knows how to restrain itself, you have to slow down and really absorb what just happened. This wasn't background noise. This wasn't election chaos. This was the constitutional system slamming into a question it avoided for 248 years and finally being forced to answer it. This is the moment everything locked into place. For the first time in U.S. history, the Supreme Court delivered a ruling that directly confronts a core dilemma. Can a sitting president or a former one face criminal prosecution for actions taken while in office? Pause here, because this is where many people miss the weight of what just occurred. That question has hovered over every modern presidency: Nixon, Clinton, Bush, Obama, Trump. And yet the system kept dodging it, refusing to write a binding answer into law. That hesitation is now over. Legal experts didn't hold back. They called the ruling big, sweeping, consequential, a massive moment in American jurisprudence. Those words aren't decoration, they're warnings. When institutional lawyers speak like this, they're reacting to the foundation shifting beneath them. That's when the gravity becomes impossible to ignore. The majority opinion was written by Chief Justice John Roberts himself. That detail matters. When the Chief Justice personally authors a ruling of this scale, it signals intentional guardianship. It tells you the court knows this decision isn't about one man, one election, or even one presidency. It's about setting the load-bearing rules of executive power for generations to come. Yes, this ruling immediately affects Donald Trump. But stopping there misses the real story. This is where the focus moves from a person to a system, from a headline to a structure. Analysts quickly identified this as potentially the most important case of the court's term, not because of political fallout, but because it redraws the boundary between personal immunity and institutional authority. The court finally put into practice a principle that had lived only in theory. Presidential power comes from a constitutional system of separated powers. Immunity exists inside that system. It is real, but it is not unlimited. Let that land. Immunity exists. Absolute protection does not. This is the moment many were waiting for. The ruling split the court 6-3 along ideological lines, with Justices Sotomayor, Kagan, and Jackson in dissent. That split matters because it shows how fragile and contested executive accountability still is. What this decision truly does is close a long chapter of uncertainty that shielded presidents for decades. And when uncertainty disappears, the system doesn't loosen. It tightens, because what comes next isn't theory. It's process. And once process starts moving, it rarely stops quietly. What the court built next wasn't a wall of protection. It was a mechanism. And once you recognize that, the ruling stops feeling abstract and starts operating like a machine powering up. At the center of the decision sit three structural pillars. These aren't rhetorical ideas. They are operational rules. Each one limits discretion. Each one shifts control. Together, they redefine how presidential power collides with criminal law. This is where the system draws its first hard line. First pillar, absolute immunity, but only at the constitutional core. The court ruled that a president, including a former one, has absolute immunity from criminal prosecution only for actions that fall within what it called conclusive and preclusive constitutional authority. That wording is precise on purpose. It refers to powers the Constitution assigns exclusively to the presidency, authority that cannot be overridden by Congress or reviewed by courts without breaking the separation of powers itself. The court's language was direct. A former president has absolute immunity from criminal prosecution for actions within his conclusive and preclusive constitutional authority. Slow that down. This is not a blanket shield. This is not a blank check. It is a narrow acknowledgement that some functions must stay beyond criminal reach if the office itself is to survive. But this is where the ruling sharply pivots. The second pillar, presumptive immunity for official acts. Outside that constitutional core, the court recognized a second layer of protection. Presumptive immunity for all official acts. Presumptive is doing the heavy lifting here. It means starting protection, not guaranteed protection. It applies at the beginning of analysis, not the end. Official acts are not automatically immune. They must be examined, separated, tested. Judges must decide case by case whether the presumption holds. This is where the gravity drops. Because the battle is no longer about whether a president can be prosecuted. It's about who gets to decide what counts as protected conduct. Under this framework, that power moves decisively away from the presidency and into the judiciary. That's not paperwork. That's power shifting hands. Pause here because this isn't normal. The third pillar removes any remaining illusion of safety. Third pillar, zero immunity for unofficial acts. The court was clear, final, and blunt. There is no immunity for unofficial acts, no balancing test, no contextual escape, no institutional mercy. Unofficial acts include personal conduct, campaign activity, or actions taken for private gain. The instant an action leaves official duty, the presidency stops shielding the individual. This is where exposure begins. Everything now turns on a single distinction: official versus unofficial. The court labeled this the decisive question going forward. Lower courts must now break down every charge, isolate every act, and classify each one independently. Yes, this will take time. Hearings will happen, evidence will be sorted, arguments will stretch on. But notice what the court refused to do. It did not stop prosecutions. It did not pause accountability. It funneled the conflict into a narrower, far more dangerous channel. Then another institutional lever snapped into place: the issue of self-pardon. The D.C. Circuit Court of Appeals shut that door completely. A president cannot pardon himself. The logic is intentionally simple. A pardon is mercy from one person to another. You cannot grant mercy to yourself. One of the most discussed escape routes is now sealed. Then the court fused two processes the system once treated as separate: impeachment and criminal prosecution. It ruled there is no immunity for crimes serious enough to lead to impeachment. None. That's not symbolic. It means removal from office doesn't end accountability. It means a presidency doesn't conclude the story. It hands it off. That's where theory turns into consequence. The crimes typically involved here carry heavy penalties. Mishandling classified documents can bring 10 to 20 years. Obstruction charges can reach 20 years. 20 years. Election interference carries similarly severe exposure. Sentences often run concurrently, not consecutively. But here's the reality: the system no longer avoids. For an elderly defendant, 20 to 30 years is effectively a life sentence. That's not drama. It's math. This is where the machinery tightens, the exits shrink, the focus shifts from rules to evidence. And once evidence becomes the center of gravity, the balance of power shifts again, quietly, relentlessly, all at once. What the Supreme Court has done is not issue a warning. It has installed a system quietly and permanently, and once installed, it doesn't care who you were or how powerful you once seemed. For decades, the American presidency operated with pressure valves, informal but real. Broad immunity theories, the idea of self-pardons lingering in the background. Delay stretched until cases suffocated. None of this was written doctrine, but all of it functioned as escape. Those exits are now narrowed, some sealed, others reduced to tight corridors.